I would like to share, for the benefit of others, two case law, professional standards, also known as internal affairs, used against me in not proceeding with my complaints against the two officers. They told me their in-house QC, Queen's Counsel lawyer, would mop the floor with me. They told me the said lawyer instructed them not to proceed with their investigation based on the case law. Later, the said lawyer would reply he did not instruct them, but merely gave them advice not to proceed after I filed other complaints. They are wrongfully using the said case law in the city, it being case law from the city, to circumvent their own mandates in doing their job, not in the best interest of anyone complaining against the local police, and most of all, not in the best interest of society. I used the letters from 2 years ago to date, which I'm about to read, not in its entirety, as evidence in my trial for the second voir dire. The judge replied, "And it is my submission that it is not unreasonable to expect that police force will follow its own procedures." The judge also went on to say that he was willing and did proceed with the trial despite not all the evidence being available for my defense. He stated, "Wait for evidence that does not exist yet." I also use other case law from other jurisdictions that contradict this local case law. Keep in mind, there was correspondences between myself and professional standards, also known as internal affairs. What I'm about to read, not in full, was my response to them. I also used the same letters after other detectives took over the case. This went on to the point where professional standards couldn't find anyone to take the case, thus diverting it back to the first two original detectives. They have no argument. Now, this particular case law is in response to their first attempt with R versus McNeil. Thank you for our meeting dated January 7, 2016 at the police station where your office is. To confirm, we added 3 more complaints against the Police Act for a total of 15 in relation to the 2 officers of May 4, 2013. Also, you had shown me 5 criminal matters regarding the said officers for review. The advice of your in-house counsel, quote, the QC who would use me to wipe my tears off the floor, with reference to him being clever, is in question. It appears the said QC in-house lawyer has in fact advised you to rely on the case law R versus McNeil in how to circumvent it by delaying, not suspended or stayed your ongoing investigation, as to not have the findings of your investigation be used against the 2 officers, which would be used for my defense, and 2, not allowing a full and proper defense to be made, preventing an counter application if needed. Now I want to pause here for a second and highlight not suspended or stayed. They rely on their letters that they send out to people who complain against police that their investigation is suspended or stayed. That is not lawful. They can't do that. And in fact, they would later change that to not basically saying they're not proceeding until my case is over. So if anyone gets a letter saying that the investigation is suspended or stayed, can't do it. And yes, I would be happy to have this discussion with any practicing counsel. The relied on case law you wrote down for me offers no provisions or remedy of not completing your now 34-month investigation. Now keep in mind, this letter was a few years ago. I'm sure I may have misread the case law, as your in-house QC lawyer has a far better understanding of the said than I do. I took the liberty of highlighting paragraphs of R versus McNeil that support the need of my ability to make a full and proper defense. Your delay, based on the advice of the in-house QC lawyer, has greatly impacted my defense. Thus appears your delaying the conclusion of the investigation is not in my best interest, but rather self-serving to, as we have discussed, the Brotherhood in Blue. You also have to keep in mind there were discussions off record, not recorded, not in print, that I had with these particular two detectives. If my understanding of your relied on case law is incorrect, then I ask for satisfactory clarification and I will retract my issues. As it currently stands, you are correct in saying your in-house QC lawyer is clever in how you have been advised regarding the said case law, not to rely on it, but rather in how to circumvent it. By not acting properly with your own investigation, your office is not obligated to forward the results of your investigation to the Crown, as there is nothing to forward, which would be forwarded to my defense via disclosure or through an application. This advice is highly unethical and breaches the ethics and the Constitution. As I have stated to you, there is case law to support an internal investigation reaching 14 months being excessive, and one example. Now here I get into case law from a higher court. You have to remember, case law from the higher courts impact the lower courts. And in this case law, the judge deemed that 13.5-month delay with their investigation was unacceptable. That was unreasonable. Now from here on in, I begin to break down R versus McNeil. This first paragraph is just simply my introduction. This following paragraph is the opening paragraph, you can say, of any case law. So when you're, say, for example, researching case law, you want to see what this one's about generally, in general. This paragraph will kind of highlight what the case law you're looking at is about. Now, you can't always depend on this particular paragraph. It's best to read the first few paragraphs, the last few paragraphs, especially the ruling, maybe skim through it because there could be information there that is very valuable. I begin here with page 73, paragraph 5. I'm only going to really focus on highlights of this particular case law and my replies to it. You can stop, pause to read. It would just take too long if I was to read it verbatim. Now here on page 74, so page 74, paragraph 7. First, the applicant must demonstrate that the information contained in records is likely relevant. I continue on to paragraph 8. Appropriate redactions. The court ordered the third parties to produce the criminal investigation files in their possession related to the charges against Hackett to the federal Crown prosecuting McNeil's case. So basically, this particular case law starts into what information would be classified, or at what times would internal affairs, professional standards, or the Crown prosecutor not forward information. Basically what they're getting into here is, for example, with real rape cases and real sexual assault cases, they would protect, say, the alleged victim's identity, their address, phone number, contact information, friends, family, etc., which all makes sense. But as you will read through here, this particular case law even supports the fact that police misconduct and events of surrounding the accused's arrest is not deemed sensitive information. So this is why, say for example, in my case and many other cases, they don't, internal affairs, professional standards, they don't do anything. It's a lot easier not to do anything, take some heat for it, and they have nothing to forward. And eventually cases proceed and things, we see a lot of injustice. Now here on page 77 in paragraph 14, the investigating police force, although distinct and independent from the Crown at law, is not a third party. So this paragraph here is very important because what they're saying is that a police officer or police department is, now page 78 paragraph 15, related to the investigation or the finding of misconduct could reasonably impact on the case against the accused. Now what I want to do is get into the actual meat and potatoes of this particular case and how they misuse it. Paragraph 23 very clearly states the duty of police investigators is to disclose to the Crown prosecutor all relevant materials in their possession. This warrant redaction of information, as I said, like addresses, names, phone numbers, and so forth. So there is a time and a place for things being redacted, but it does not apply to cases where police officers are alleged victims. Here we get into how a third party privacy interest is unlikely to defeat an application for production. So this is basically goes on to why professional standards hasn't done anything with the investigation of my case. And as with other cases involving police officers, whether it be they're alleging to be assaulted or they're alleging defense with cases, this is why they get away with it. This is why they get away with murdering people and beating people and all sorts of nasty things, because the police who are supposed to police the police don't do their job. And really all this comes from their unions. So the biggest problem with accountability by the public against the police is the unions. Paragraph 42, a finding of true relevance puts the third-party records in the same category for disclosure purposes as the fruits of the investigation against the accused. The accused's right to access information necessary to make full answer and defense will outweigh any competing privacy interests. So there might be an exception, say with a real rape case, that the defense, the lawyer for the defense, would need to talk to witnesses of the alleged victim. Now, page 93 is very interesting because the judge says it would be perverse to hold that investigative information, and continues on to say the Crown to use it to seek the conviction of the target of that investigation, yet that same information is protected by privacy interests when it contains relevant information that would help someone defend himself. That right there speaks volumes. It's mind-numbing how the police, local police here are trying to rely on this particular case law, but there's only one thing in each of the case law, McNeil and Yip, that they really focus on, and it doesn't really mean anything. So page 93 to 94, paragraph 44, the same applies in respect of police disciplinary records or any other third-party records. The court should ensure that a production order is properly tailored to meet this particular case. And goes on to say, this does not mean that only material that would be admissible at trial should be produced. This is very important. So here I get into my case and my reply to that with the trial beginning of November 2013. You have to remember that the case actually began for me in December of 2012, and the police assault on me took place on May 4th, 2013. So I continue on to cite case law that I'm relying on. Now on page 96, paragraph 48, that there's an onus on the Crown Prosecutor to be firm with the police with regards to information that they have. Page 97 to 98, paragraph 50, applies when the Crown Prosecutor is informed of potentially relevant evidence pertaining to the credibility or reliability of the witness in the case. The Crown and the defense are not adverse in interest in discovering the existence of unreliable or unethical police officer. Crown's failure to inquire further when confronted with the perjury of its own witness. Now, this is very much relates to my case because, as I've stated, during the November of 2013 trial, the officer, even the Crown Prosecutor, seen that he was lying, and the case still proceeded. At that point, if not before the trial began, the Crown should have withdrawn everything, but didn't. So this particular case law continues on with its own witness perjury and the fact that the perjured evidence coincided with the incomplete disclosure. The Crown was obligated to take all reasonable steps to find out what had happened and to share the results of those inquiries with the defense. The Crown did not fulfill its obligations. And this is interesting because my complaints, for example, against the Crown Prosecutor, the Law Society of this province found there was no merit to it, but yet there's evidence in the transcripts, and even later, during the Section 11B argument, the Crown admitted to his mistakes, the trial lasting too long and everything else, and yet I'm still convicted. So on page 98, the judge focuses on the police department's duty to participate in the disclosure process. Page 52, there's an obligation accords with police codes of conduct. And it goes on to say a police chief or other police officer commits negligence of duty if he or she fails to report anything that he or she knows concerning a criminal charge or fails to disclose any evidence that he or she or any other person within his or her knowledge can give for or against any prisoner or defendant. This here, I'm just going to back this one up, speaks volumes. This means that it's not only the two officers and now the two detectives, but we have a whole array of people, including the police chief, who are on the hook. Now, what's interesting, since my case had began, I believe the police chief has changed 3 times now, if I'm not mistaken. So this is one way that they keep shuffling everyone around. No one's accountable. On page 98, 99, paragraph 53, it talks about the disciplinary information that is relevant. It should be part of the first party disclosure package. So for example, in my case, if the officers have a history of lying and beating people and all this other stuff, then that information would be relevant to, in this case, my defense. Now, page 99, paragraph 54, again, it goes with police misconduct in question concerns the same incident that forms the subject matter of the charge against the accused, the police duty to disclose information. Excessive use of force in relation to the accused's arrest. This information must be disclosed to the Crown. Police witness is not directly related to the investigation against the accused. It may nonetheless be relevant to the accused case. This is the case law that they tried to rely on in the beginning and not proceeding with investigating my complaints. Page 101, 102, paragraph 59, relevant material, whether it be for or against an accused, is part of the police duty to participate in a disclosure process, is obvious relevant to the accused case. It should form part of the first party disclosure package to the Crown. Well, we read earlier that police information and so forth is considered first party. It becomes incumbent upon the police force in fulfillment of its duty. Now, paragraph 60, necessary cooperation between police, the Crown, and defense. Now, in this case, paragraph 61, the accused was successful with the appeal, higher court ruling. And here I just continue on with my response to everything. And here is the conclusion of that response. So now I'm going to look into the next case law, R versus Yip. So now I'm going to review R versus Yip. And again, this is the letter that I had wrote. I have reviewed the cited case law the Calgary Police Professional Standards is now relying on. Now, this is after my reply to R versus McNeil. Now, this particular case law is the one where there's a recommendation with why they should not proceed. This also fails too. It should be noted that the paragraphs you highlighted, quote, I would ask that you pay particular attention to, falls under the heading, quote, suggested resolution, to mean a recommendation rather than it being an absolute. This is further supported by the ruling of the said case law you have provided. I would ask that you pay particular attention to paragraph 33. Now the quote of paragraph 33, order the police service to provide the Crown with any information they request from the police investigation of the same incident as the charge before the court as a result of the two accused complaint against the arresting officer. Now, they cite in R versus Yip, McNeil, that they must disclose. So basically, when Internal Affairs Professional Standards relies on McNeil and Yip, their in-house lawyer tells them, because of this case law, don't do anything. But there's nothing in the case laws themselves that say you're allowed not to do anything. So when these detectives and everyone tell people we're relying on McNeil and Yip, they actually should have kept their mouth shut. The said ruling does not support the position of the recommendation of an amendment to the Police Act as you highlighted. In fact, very much the opposite. There is nothing contained in the Police Act to reflect such recommendation has been adopted in approximately the 6 years this recommendation was made. Therefore, hiding behind the guise of R versus McNeil, as I explained in my previous correspondence to that case law, fails, meaning, but not doing anything omits the obligation by professional standards to forward any findings, ultimately to the defense, in this case me, as there is nothing to forward. I believe the civil defense lawyer for the police stated it well to the case management judge that forwarding such information would incriminate the two officers relying on the now said case law fails. My complaint against detectives remains. Because the highlighted paragraphs are only recommendations regarding the Police Act based on the opinion of the judge, and such recommendations have not been adopted by the Police Act, any further address is not necessary, thus a moot argument. However, I will do so simply as an exercise when I get into reviewing R versus Yip paragraph by page and by paragraph. But I'm not going to read it, but basically there was a recommendation stating that investigations against police officers should be, by law, suspended or stayed until the accused person, the one they accused, their case is over with. Now keep in mind that by that time, if the accused is found guilty, then that's the defense of the police officers for any crimes that they've committed. It's also a way for them to mitigate their damages. Anyway, moving on. This recommendation that they use has to do with medical examiners. The medical field has nothing to do with law, politics, or police. Now, this recommendation, this is a case from this very city that the alleged concern is that people will simply abuse the process, and it doesn't even make any sense when you read it. I go on to say how the officers are the alleged victims. Now imagine if two people, civilians, got into a fight or something, and the police decided for whatever reason that they're only going to investigate one side of the story, there would be no defense or defense lawyer or court or anyone that would go along with such a ridiculous notion. They would investigate both sides and find out what happened. Now, it appears that the police in the city, they're exempt. So, as a defendant, I only have half the story. Now, I'm trying to scroll down slowly here. Now, here's some case law that I have presented. And again, all these things I've also used in my trial. Some of the case law that I used in criminal code references and so forth is outside of the box, which means not going along with the status quo. I'm basically getting into how the internal affairs professional standards lawyers would hinder any testimony or any evidence an officer would give. Again, citing more case law. The bolded parts are things that I wanted to emphasize. The judge in this particular case here really hammers on professional standards, internal affairs, saying that your letters that they send out every 45 days is just a formality. It's not worth anything. Here, the judge saying that it is distressing that 4 years after a prompt complaint, nothing has been accomplished. How many other complaints lie in limbo because of the policy of delay, we do not know. Another case law. Again, I used these case laws in my trial. Everything ignored. R versus Kelly had concerns with the police testimony. R versus Ford is one that really caught my attention because police evidence is entitled to no more or no less credit than any other witness. And when you talk to local defense counsel in this city, they all try to bullshit and say, well, police are treated more special because of their police officers. And if you mention R versus Ford or challenge them on that, they basically hang up the phone immediately. Now, I reference the Canadian Criminal Code. Also during the trial, I made a reference to a section of where in the Canadian Criminal Code, it's mainly applies to employers and employees. If an employer cannot instruct an employee to do something that is dangerous, or they even deem dangerous, So in this case where the officer was threatening me with his hands up, tone of voice and demeanor and everything, telling me to get out, it's too late for that. Under the Canadian Criminal Code, no one has to abide to that if they feel threatened, if they feel that their safety or their life is in danger. I even reference the Provincial Police Act, Section 51A and B. And very good point that I make here is it is unfair that simply because two officers had the advantage of filing a complaint first, I would have liked to have that opportunity myself. And I'm basically just concluding my letter. I had filed Freedom of Information requests, as I mentioned in my other videos, and yeah. One final thing I would like to say is that in the history of this city, not one case against police officers has been successful. We see why. And even working within the confines of law, like I have, not arguing nonsense of what these I don't even know what they're called, freemen, land people, whatever. They won't let you win. They will blatantly lie, cheat, and steal to convict an innocent person to save face. I hope that my sharing my letters with regarding to R versus Yep and R versus McNeil are helpful to other people. And if there's any questions, feel free to contact me. Thanks for watching. Please like and share. And good luck to anyone in the criminal justice system in this province and in this city.